I was also trying to understand how will the governor work under the Article 200. I think, firstly, there are composite lines of reasoning. The governor will first find out whether, I'm not talking about the aid and advice proposition. I'll show the absurdity if you have to go along the aid and advice proposition. The governor will have to first find out before he gives assent whether I should withhold assent. Then, if it is not a question of withholding assent, if he thinks it should be sent to the president, he may examine that possibility. If both these possibilities do not exist, then he will assent. Therefore, you have to go by ruling out, like in Sanskrit, you say, neti, neti, not this, not this. Therefore, once I rule out withholding assent does not exist, is not available, and sending it to the president is also ruled out, then automatically I'll give assent. But after I say I'm withholding assent, then all the judgments about falling through will come in. That's why also, even after withholding assent, if there is a difficulty, if the genuine independent exercise of judgment by the governor says, I should send it to the president in order that on a repugnancy question, the president will have the final say. Therefore, it's the flexibility and the dynamics involved by the governor's independent exercise of judgment. I mean, how do you keep it intact? Would you keep it intact, or will say, no, we'll bring as many restrictions as possible, or the court may conceive? So this process of reasoning under Article 200, that's why I'm saying, notwithstanding all those debates in the Constitutional Assembly, we dropped the word discretion. Section 70 of the Government of India Act dropped it. From there, we dropped it. The 175 draft article, we thought we'll have something else. Notwithstanding all that, at the end of the day, if Article 200 says, I'm giving certain options to the governor to act within these 4 options, these options, then the governor has a course of action. Options are predetermined. But what will the governor do as long as the options are concerned is a course of action to be done and undertaken by the governor herself. So in the course of action, now we'll say, now I will find out which course of action is good for you. So all that we're trying to point out, Lordship, the course of action must be entirely based on an independent evaluation by the governor. That's a core, I think, function in Article 200. To compare Article 163, 361, discretion is not found here, etc., I think is completely alien argument. It need not have a place in discretion, may not find a place in Article 200. The moment there are options, and the options, the governor has given a course of action between the options, it means a different set contemplated in Article 200. I don't think we need to go into the word discretion at all. We are falling into a trap, I would say, if we want to use the word discretion in one particular way, in one context, in a different way, in a different context. I don't think we need to get into the word discretion at all. But if you want to use it, I say that it must be equated with an independent exercise of judgment by the governor within the 4 options given to him. So if English language does not have any other word, let's not worry about that. Constitution says 4 options, exercise your judgment. So having said that, sometimes happens, we talk about all this constitutional silence, very attractive proposition. Since, I give me the article. Where is it? I don't propose to take a lot of extenso on reading any judgment. Judgments have been read in extenso. I only wanted to bring this very broad concerns. And I think once the broad concerns are appreciated, I'm sure the Lordships will take a view as to where a line will be drawn, or the court will not say that we are not deputy legislators and to draw lines which the parliament will draw. Yeah, volume 4.30. Lords, just